I got a call from one of my advocate friend this morning saying that yesterday there was a landmark judgment by the Honorable Supreme Court of India. Are you not going to cover it? I told him it is already available everywhere. Then he asked me to cover it structurally. So here is my attempt to see section 6 of Hindu Succession Act, which is a big question which is being interpreted in different cases in different ways, and finally Supreme Court yesterday has given a landmark judgment by saying that the girl or the daughter also inherits the right to property equally to a son when it comes to Hindu Succession Act. I have detailed presentation. Now I am giving option to you. If you want to understand the entire story, you can watch the entire video where I am covering section 6, the important case laws, and finally what is there in this particular judgment. But if you are in hurry, you can straight away go to the last slide where I am discussing everything related to this particular judgment. So that's how I am giving an offer to you. With that, let's see what exactly is there in section 6 of Hindu Succession Act, which is being amended in the year 2005. Before discussing anything, we need to know the case law that we are discussing about. It is Vinita Sharma versus Rakesh Sharma. Now, one reference I would like to bring here, that the Karnataka High Court gave a judgment in Pushpalata NV versus Padma case on 25th October 2018, and if you compare the judgment between these two, it is almost similar. But unfortunately, the Pushpalata case is not being referred in anywhere in the current judgment copy. I don't know why that happened, but that's how it is. However, let's move to the section 6 of Hindu Succession Act. The first and foremost, the very important aspect that we need to observe from the Hindu Succession Amendment Act 2005 is their section 6 was not amended. It was being substituted. That means whatever was there in section 6 till then was being scrapped off. So whatever comes in the new section 6, whichever has been added by the Amendment Act 2005, is a substitution. That means from the day 1 of 1956, from when this act came into existence, this particular section need to be read. That is what we need to understand. That was not very clear, and that's why we had lot of confusion. Now, before even getting into confusion, let us try understand what is very important under section 6, which came in the year 2005. I am not getting into full detailed discussion on section 6. Here I am going to give few key information as far as this particular section is concerned. So firstly, let us try understand what is very important aspects which are being covered under clause 1 of section 6. Now, it covers about the right of a girl child in Mitakshara law. Now, what is this Mitakshara law? In India, we are having two different base of law, that is Mitakshara law and Dayabhaga law. In Dayabhaga, there is a lot of importance is being given to girl child already, like the state of West Bengal, etc. Whereas the major portion of India belongs to Mitakshara law, where girl child never had equal right in property. But with this amendment, they very clearly told a girl by birth become a co-partner in her own right in the same manner as the son. That is the first subclause, that is subclause A, which very clearly says that the girl has same right as son. And subclause B, have the same right in the co-partnery property as she would have had if she had been son. Now, what if she were to be a boy? She would have got property share. Likewise, she will have under subclause B. Then comes subclause C. This is very important, which confirms A as well as B, but then says if there are any disposition of property or alienation of property, including partition or testamentary disposition, they cannot be a dispute if they were to be done before 20th day of December 2004. This is done basically to avoid any kind of litigation for those properties which are being already disbursed or aliened before 20th day of December 2004. But if there are any properties which are being partitioned after 20th day of December 2004, then definitely it will become a matter of dispute because section 6 gives such right. That's what we need to understand from clause 1 of section 6. I am now taking you guys to clause 3 of section 6. Clause 3 covers a very important aspects which says the right to such daughter is not by survivorship and the co-partnership property shall be deemed to have been divided as if a partition had taken place. Now, whatever is being considered for son when he is dead, the same needs to be considered with the daughter. Like son's family would have got all his property when he is dead, likewise the daughter's family would get all the property whatever she was supposed to get. That is how we need to see the right to equality between son and daughter when we are looking at section 6. All of these were very clear. But then the interpretations made a lot of mess. Let us see which were the important case laws. These were the few important case laws. They raised certain number of questions, they answered certain number of questions, but they confused a lot. The first one is Prakash versus Fulvati. Here it was admitted that section 6 has retrospective effect. However, on 9th September 2005, if both daughter as well as the father is alive, in that case only the daughter would get the right of property. Likewise, in the case of Mangamal versus TB Raju, it was held that on the implementation of this Amendment Act, both daughter as well as the co-partner need to be alive to ensure that the daughter has the right in property. There are many other case laws which are being referred. I have given for your reference. Now let's move to the very important slide where I will explain what are the important aspects of new judgment that we need to understand. The first and foremost important aspect we need to understand is section 6 is not an amendment but substitution. We need to read the new section which is being inserted. And the second one is such amendment is retrospective and not prospective. That means from the very first day of the law, that particular section is applicable in law. That means from 1956 itself, section 6, whichever has been amended in the year 2005 and substituted, will play the role of original section. That is what we need to understand. And with this judgment, right to property is now equal between sons and daughters or son and daughter. Section 6 is not just about rights, it also discusses about liability. So we need to understand the fourth important aspect, that this particular right also brings liability. That is what we need to remember. That's the fourth important aspect. And fifth one is such rights and liability will be by birth. The moment she is born, she gets her right over her father's property. And such birth need not to be after 2005 or after 1956. It can be at any time. Even if she was born before 1956, she has the right over her father's property. So the sixth important aspect you need to note is there is no restriction of timeline. Seventh one is it is not necessary that her father or the co-partner is alive, and eighth one, it is not necessary that she herself is alive. If she is not there, her children or whoever is legally eligible to take her property will get the property. Just in the case of son, like widow or his children get the property, here daughters, the belonging people, will get the property. That is the eighth aspect we need to observe. The ninth important aspect, which I have already explained, that the property, if already been distributed before 20th December 2004, they will not become a topic of litigation, and Supreme Court has guided all the High Courts of India to see and conclude the pending cases within 6 months. That is the 10th important aspect. Finally, there are few cases which are partly overruled. They are Prakash versus Fulvati, Danamma versus Amar, and Mangamal versus TB Raju. That's my time on this particular judgment, and with that I am concluding this video. Please subscribe my channel, please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.